On Tuesday, the Supreme Court heard oral arguments in an appeal from a former Pennsylvania police officer named Joseph Fisher, who was charged with multiple crimes for shoving his way into the Capitol on January 6th. You can see him there doing just that in a blue ball cap. He was charged with obstruction of an official proceeding, which in this case, of course, is the congressional certification of the 2020 election. Hundreds of others have been charged or convicted of that as well. And he wants that felony charge dismissed. And the conservative majority of justices sounded skeptical of the charge and sympathetic to Fisher's argument that obstruction law should only apply to evidence tampering and not, say, a congressional proceeding to certify an election. Here's the thing. Hundreds of accused and convicted insurrectionists have been charged with this particular obstruction charge, and so was Donald Trump. And the court appeared to hold, in oral arguments yesterday, a sudden concern about the First Amendment right to peaceably assemble, the possible use of this statutory charge by the government to overreach and criminalize it, which itself would be a perfectly legitimate concern if it weren't for the fact that on Monday, the day before those very same oral arguments, the same Supreme Court once again acted by not acting and allowed a lower court ruling to stand that would effectively make it legally impossible to organize protests in 3 states, particularly Black Lives Matter protests. In that case, a Louisiana police officer was injured by a protester, and he sued the man who he said organized the protest. And a federal court of appeals found that an organizer could basically be sued into ruination if a single protester commits an illegal act. The man who police say organized the protest in question was DeRay McKesson. And DeRay McKesson, whose name is on that suit, civil rights organizer, Black Lives Matter activist, also host of the podcast Pod Save the People, joins me now. It's good to have you here.
It's good to be here.
So I just want to sort of walk people through this. This was a protest in Baton Rouge, I believe, right, in 2016?
After the killing of Alton Sterling.
And you were, I imagine, one of a bunch of people that were organizing protests, right?
I wasn't organizing it. I was just out there supporting people. I was tweeting about it, getting people to come in terms of Twitter, but I was not one of the organizers. We've repeatedly said this in all of the legal documents.
You're just like a person who was protesting.
I was out there supporting the protests, and I was actually arrested pretty quickly. It was the photo that you had up. Yeah. So I was in jail for 17 hours. So I was as shocked as anybody to get charged with this, but I was actually sued by 5 police officers. We got them all dismissed, including this one. They appealed, and then we lost on appeal. So I've been dealing with this loss on appeal since 2016.
And I just want to be really clear here because there's some pretty firm precedent, right? Like, it cannot be the case that you could have a functioning First Amendment with the right to peaceably assemble and the right to have protests if any police officer who happens to be injured by one person at that protest could then say that this other person is civilly liable for that injury, which is the theory of this police officer, and which the Supreme Court in past precedent has said, no, that it doesn't work that way.
Yeah, there's a historic case, NAACP versus Claiborne, that says that you can't sue a protest organizer if somebody else just commits an act of violence or destruction. What is wild about my case, though, is that we've never actually had a trial or a fact finding. The court has to take his allegations as fact. So the idea that I actually organized it, they have to take as fact.
Right.
Did he even get hurt? I don't know. He's never produced anything to say there actually was an injury.
But this is just about that threshold legal issue. Like, do we want to open the door?
Yes.
And there's other examples, too. In 2023, the court had another case, this Countryman case, which Sotomayor talks about in her note, saying, wait a second, we already have court precedent saying this is nonsense other than this other finding. So, like, it seems to me you've got a real rogue Fifth Circuit here that is opening a very dangerous door for peaceful protest.
Yeah, remember that this case, we went to the Fifth Circuit twice. We got split opinions both times. We went to the Supreme Court twice. This is actually the second time at the court. The first time, the Supreme Court said, we need to ask the Louisiana State Supreme Court if you can be sued. So we go to Louisiana. They say, yes, I can be sued. We're like, well, that's not good. So then we come back to the Supreme Court. And thankfully, Sotomayor's statement makes it so that it'll be very hard to apply the Fifth Circuit's logic in the decision they made about my case. So that is a good thing.
Yeah.
So her decision.
You seem confident at the lower court level.
Yes.
This is like basically temporary.
Yes. We think that Sotomayor's statement is actually going to make it impossible to enforce what the Fifth Circuit did. We also feel confident that we're going to actually win my case when we actually go to court, and that people should not be nervous to protest in these 3 states. The ACLU has said that they will represent people if another officer does try to invoke the Fifth Circuit decision. But we are thankful that Sotomayor's note actually does sort of make it really hard to apply. We wish that it had been a more forceful, the court, summary reversal.
Yes, the court should have. The court should have stepped in and been like, "This is wildly out of line with our precedent."
He got relisted 5 times. This is a wild case.
It is a wild case, and 8 years on the notion, in the face of all precedent and all logic about the First Amendment, and the importance of civil disobedience and protest in this country's history, to create this liability standard is just. The implications of it are bizarre.
And to get caught up, I'm thankful that the ACLU supported me, David Goldberg, Billy, all the lawyers have been incredible. But the sheer amount of time and energy it has been to turn over the text messages. I got deposed in this case, but the district court case got put on hold because we were waiting for the Supreme Court. But now we have to go back to district court in Baton Rouge.
This is part of both sort of the lawsuit itself, the Fifth Circuit's logic, to the extent the fact that the Supreme Court didn't step in to proactively say this is nonsense. It seems all of a piece with a lot of backlash against protests we've seen from the right. And I wanted to ask you about Senator Tom Cotton of Arkansas, who was talking about people protesting the war in Gaza, who were stopping traffic, who had placed themselves, and basically said you should take matters into your own hands. He also said that they may have to have their skin ripped off if they were glued to something. What does it do to American democracy to have prominent folks like that in prominent positions with their sights on protesters in this way?
Yeah, I think their intent is to have a chilling effect so people won't go to the street. The good news is that there's a long history of civil disobedience in this country, that the civil rights movement, I think about 2014, it's going to be 10 years since the protests in Ferguson that birthed a movement and a generation of people coming to the streets. And I don't think that's going to stop. I think that we see with the protests around Gaza, the protests around abortion, that people are continuing, are not scared because of senators like Cotton making wild statements. And, if I said something like that, I would have another court case against me. And that would be very quick.
You're right. You are absolutely right. If they could find you saying take matters in your own hands,
oh my God,
you would be in a lot of trouble. DeRay McKesson, it's really good to have you here.
Good to be here.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.